Hey everybody. I took my poor head looks so dry, y'all. Hey everyone. Hi. Hello, 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 hello everyone. Welcome to Infamous Sylvia. There's a lot that has happened within several hours. A lot has happened. I don't know where to begin, but let me just thank you guys for being here. Thank you guys for being here. This has been a whirlwind of events on top of events. I don't know where anything is going at this present time, but you guys know there's a halt. There's a halt in the YSL Young Thug RICO trial. Okay? It's a halt. You guys have to just experience being there today. It was definitely I saw the feeling of defeat. I saw some form of joy. I saw some connections between people. I've seen relief. I'm talking about just in today's setting. Okay. I saw some confusion. I saw some people confused. And I saw some people who were nowhere to be found when the stuff is happening. I saw humility. I saw confusion. Saw some confusion. What I'm going to do is I'm going to show you some things that it's not shown anywhere else. Nobody else has it. And I'm not trying to be funny or anything like that. But I'm going to show you guys the atmosphere of what was going on while Judge Glanville was rendering his assessment of what happened as far as the ex parte meeting. And then I'm going to give you some insiders of me asking questions and me watching and going around trying to put some pieces together for you guys. Okay. Putting some pieces together for you guys, showing you the human side of what was happening. Because sometimes when you're not in that setting, you may not be able to understand or feel what's going on. But I decided to take some videos and some pictures for you guys to see what was happening. Because, I was trying to text and keep you guys abreast what was happening. I wasn't answering everybody's question, and that caused some sort of like confusion, right? And I'm going to explain to you what have the transcript been posted? No, but I'm going to show you why it hasn't been posted. There was a motion submitted by Miss Love, and I'm going to show you why things are like there's a hold, and I don't know why. It's some sort of like weird thing that's going on. But and I know everybody's trying to get a piece of the pie. I know everybody's trying to report on it and tell what went on in the courthouse. They weren't there. The only blogger, content creator on YouTube that was in the courtroom was me. Nobody else. Okay? Nobody else. And that's why I'm going to show you stuff that other people don't have the privy of having. Okay? And I understand everybody wants to eat off of this case and things like that, but the labor They didn't labor through this. And I'm not being mean or anything. I'm just being serious. And they know how to do the click. That's why I said it's not clickbait. They know how to do clickbait and all that. And it's frustrating, but it comes with the territory. It's a doggy dog industry, and I understand that. I'm a newbie, and I know how. All I know how to do is work. All I know how to do is work. So let me go ahead on and show you guys what I have. It was definitely the connector. It was definitely a moment in time. I seen some defeat. I've seen some defeat. I've seen some defeat. But let me go ahead on. Let me put this my logo up, and so you guys could see. I did 3 different angles for you guys. This tape here is going to be one camera facing the defense and all the attorneys that was there, and then I have the other camera showing where Miss Hilton. You get a view where she's doing and things like that, how she's handling everything that's being said and things like that. So without further ado, let me go ahead and bring this up for you guys. Okay. This is from the angle of the attorneys. Okay. Here we go. Hey, everybody. You see Harvey in the background? Jeffrey has his headphone on. He's listening to something. You see his head bopping. Okay. The attorney that's sitting in the front, that's Steele's attorney, and then the other 5 attorneys are Miss Bumpus' attorney. You didn't see this one on live. This is my camera. You didn't see this one on live. In considering whether or not to begin discussion, this court has decided to release the entire transcript of those proceedings as courts want. And I'm going to take judicial notice of the following time. On Friday, June 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A. Now we mark this court's 2. So transcript in court 1 is immunity from Mr. Copeland in court 2. Mr. Copeland, who was represented by Mr. John Melnick and advised of his rights and obligations during the proceedings on Friday, June 7th, which will be marked as court's 2 in the transcript of the proceedings. Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt of court's 4. Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings as he would be on leave effective 10 June 2024. The court informed Mr. Melnick that his leave or discussion with him his leave was not proper, and he needed to be in attendance on Monday, June 10th, 2024 with Mr. Copeland. Mr. Melnick relayed that Attorney
Office will be representing Mr. Courtroom. On Monday, June the 10th, before court, the chairman was litigation manager informed the court that the state wished to have an ex parte meeting in court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christine Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Taylor Bumpus, attorney Brady and Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were Attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, with the court and security personnel, deputies Houston.
Look at Box with his cup, y'all. Look at Box with his cup.
Sergeant Brown and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with Attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:59. That would end up the transcript of those proceedings starting as of 11:49 when the court presumably held the proceedings on 10 June in courtroom 1C 2024. That would be marked as court's 5. The proceeding in 1C commenced on the record at 11:52 a.m. A last recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion that was at 1:46 p.m. In asking Mr. Steele was held in contempt, however, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told him at that time. Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, as mentioned, Mr. Alex Cecil entered the courtroom. Mr. Steele was held in criminal contempt. That contempt would be marked as court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Brian Steele, in open court upon information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of Court's 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1C, which of course I said be part of this order. The first assertion and the transcript bears out Mr. Steele So the court is paraphrasing the six assertions that Mr. Steele made. I'm most happy to put in the record. The first one involves his concern that supposedly in chambers, this honorable court at times district attorney or district attorneys for the DA's office, as well as investigative sheriff and deputies. Mr. Copeland and his counsel met together. None of the defense team to acknowledge were present. Second assertion he makes is that Mr. Copeland intended to plead the fifth. The third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was in fact a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not wanting to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness to include the court involving allegations of coercion and witness intimidation, and that he is his counsel present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court, in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought to investigate any facts that was involved in this footage, and only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. As I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers, not for whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June 2024. One, he asserted that this was, on behalf of Mr. Anderson, that this was the court held an improper. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. And no, Mr. Copeland was a sworn witness. And thirdly, he argued that this was a critical stage, and that he and others needed to be present at that point in time to proceed the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court has got Judicial Code of Conduct 2.9, which will take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of ex parte communication, and the judge makes provisions properly known to parties. The substance of the ex parte communication is parte to respond, and in this particular circumstance, the transcript of these proceedings was just prepared and is filed by my official court reporter, Ms. Weaver, And all counsel will be, as I said, given an opportunity to, as soon as the court finishes their its order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and for the last part of 2.9, if involves in pertinent part, if a judge inadvertently receives ex parte unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties the substance of the communication and provide parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit, and before any other further examination is called. I'll address the issue of the emergency nature of this particular hearing, of this particular conference in front of the court. Is that this involves the state's concern as to what Mr. Courtroom was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5-507. And that the conversations that were had in the transcript will bear out no technical or other advantage or any testimony that was stated during that particular hearing will be anything other than the court and or the state communicating along with responses his the entire time. His witness understanding his immunity. In consideration of this emergency nature, the court is taking into account a couple of cases outside. One of them is United States versus Adams, and that's 785 F2nd 917, decided March 31st, 1986. In pertinent part, presence of the accused. Although an ex parte conference to discuss threats against the witness's property, district court must ensure that the conference is carefully conducted so the no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal is not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed. And in Adams, the appellants contend that the ex parte conference was improper and violated their due process right to a fundamentally fair trial. We agree with the appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations the trial judge may find an ex parte conference necessary. Cited La Chapelle, LACHAPPEL versus Moran at 699 F2nd 560. So first, the court cites in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others who could defend. One such extent conference may be where a juror or witness has been threatened and wishes to speak with a judge privately about the threat. A witness may not feel free to discuss any threats in presence of the defendant. Reading counsel for the defendant, we agree with the First Circuit. The ex parte conference is appropriate in this situation. SEC United States versus Royal. It's ANGULA. It's 5 1152, 1142, 1141, 1142, second circuit case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. Citation for that. 439 U.S. 915. Although an ex parte conference is considered as proper, The district court must ensure that the conference is carefully conducted so no rights are offended. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Cooley's inculpatory testimony discussed. And second, the entire conference was transcribed. In this United States versus Watchmaker, 761 F. 2nd, 1985, ex parte conference, fracture, properly transcribed. Carefully framed. This court goes on to say in Adams, two aspects of this conference are disturbed. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and for protection, the trial court should have called the conference to a close. A portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection. There being no reason to participate in such coaching. Second problem occurred where Cooley took the stand. Defense counsel inquired what inducements had been given for Cooley's testimony, and the prosecutor and Cooley both indicated only the promise was the prosecutor would seek to enroll Cooley in witness protection program if he were to interfere with his life. Neither related to the prosecutor's pledge to seek immediate protection for Cooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made in the ex parte conference were completely precisely disclosed. Similarly, in this matter, the only thing discussed between the state and counsel for Mr. Coleman and his court with understanding his testimonial statements made by Ms. in terms of what Mr. Coleman planned to testify to, that reduced or sought by the court in transcripts to tally. The court has also considered Bruner versus the state. That's 302 Georgia 6, and this relates to the right to be present. What is defined as a critical stage under the Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present and see and hear all the proceedings which were had against him on trial before the court. Ward versus the state 288 Georgia 641 in 645. Violations of this due process right of presumed prejudice should absolutely be provided trial. However, there were no violations present. The right to be present attaches to any stage of criminal proceeding that is critical to its outcome. The defendant's presence will contribute to the fairness of the procedure. Top versus the state 274 Georgia 110. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights can be lost, defense is waived, privilege is claimed or waived, one in which the outcome of the case is substantially waived, and just to get the case. The fourth, I think, in case law. That this was a proper ex parte immunity pursuant to 2.9, as well as the both party being in attack advantage and the proceedings as a whole, these two in terms of transcripts of what said and utilized by defendants. Okay, the court lastly took into consideration Halted versus the state. That's 368 Georgia Appeals at 313 and Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part of many circumstances, many instances where it will be necessary for the presence claim to its constitutional rights for the first time appeal and criminal conviction. So Mr. Seals raises at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of criminal proceeding, which is critical to its outcome. The defendant's presence will contribute to the fairness of the procedure, but the right does not extend to situations where the defendant's presence will be useless or benefit by shepherd. And under the Georgia Constitution, the defendant who is represented by counsel need not be present for the portions of the trial involve questions of law and consists of essentially legal argument about which the defendant pursued has accomplished. It is well settled under the Georgia Constitution guarantees the criminal defendant right to be present and see here all proceedings which are had against him in the trial before the court. It's Prickett versus the state, 314 Georgia, 435, 441, pinpoint. This right attaches to any stage of criminal proceeding that is critical to the outcome if the defendant's presence will contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence will be useless or benefit or shepherd. The court further takes no position on whether Attorney Bumpus disclosed confidential or attorney-client matters. The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and our Supreme Court. The court further takes no position on whether Mr. Steele his use of the June 10th proffer information as his use on behalf of Mr. Williams falls within the guidelines set forth in the Georgia Rules of Professional Conduct. The court's basis for having been explained on the record, a written order of this along with the attachments will be included in the record. And Mr. Banksworthy.
Yes, sir.
As a result of this transcript release, the court withdraws the show cause for the client and others who may be present for the present in chambers on the 10th of June 2024. As I mentioned earlier, we were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely. In fact, I canceled all of that, so we will not be particular hearing. Okay.
Thank you.
Then as a unrelated, then transitioning to the last matter. Upon further review, this court will in fact sending Mr. Adams and Steeles, Mr. Weinstein, and Mr. Banks motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our rules. So this written order is entered the order transferring it, and until such time as that those two things are decided, and we will be recessed to come out. And we will just inform our jurors that they're continuing until this is they're supposed to make money until Monday. So Ingram just still on recess. So that's all I have.
Sorry. Just to know that I'm trade bonds.
Ms. Hawley, can I ask you a question before you start?
Yes, sir.
Didn't your law firm represent one of the co-accused in this case? How are you then? Do you have an actual perceived conflict in this case?
No.
How have you been, I'm asking at this point in time, could you state for the record how it is that you don't think you have a conflict? Because you did represent one of the co-accused in this case, correct?
I did.
Okay.
Your Honor, this has absolutely nothing to do with my representation of surgery. I mean, the stuff that are called, and what happened in the ex parte proceedings, we're just representing this office, attorney office, and what her position is with respect to,
Yeah, you're good now.
with respect to this court. So, completely different matter. Now we're dealing with the contempt hearing of this office as opposed to a criminal prosecution of misintentions. Completely different. In fact, everything that we've gone through or anything we've learned about this case has nothing to do with what we've done with the attorney office.
No, that's fine. I just wanted, because you may have an actual or perceived conflict, I just wanted to bring that to your attention. So if you think that it should be addressed, and I'm giving you the opportunity to do so at this point in time. Because you do have knowledge of this particular case, right? All right.
Well, I think half of America
I'm sorry.
So I think half of America has knowledge of this particular case.
Well, they did, okay. But they're not before us at this point in time. So what else did you want?
Well, and I'll speak for the court's purposes. I'll speak for myself and John Garland, who's also our co-counsel with the jury office, and he was my co-counsel in this case. So speak for both of us in that respect, since Mr. Garland's not able to be here. A couple of things that I just wanted to clarify, Your Honor, is the court still continuing to produce an order on what the court addressed orally on a recusal motion?
Yes, I'm going to produce an order basically bundling all, since there are three motions to recuse to one, to be spun on the wheel so that we don't get three separate people hearing these particular matters. So I will do that today. So does that answer your question?
It does with respect to that. The other issue is I think the court was going over advisement on motion to quash.
That makes this moot at this point in time. Since I'm not going to have a hearing.
Look at them. Yeah, they're shaking their head.
But I'm telling you, at this point in time, I have no desire to resolve that. I don't need to.
All right, these are the questions.
Look how they looking at each other, y'all. Look.
Anything else you want to be excused? Councilors, I'm going to go ahead and work on this. Order. Actually, memorialize the order of the motion to recuse in terms of the sending it to another judge, 25 months from 25.7. And we'll see in a little bit, depending on how it's going. That has to go to another judge pursuant to our local rules. So it will be basically put on the wheel. Of course, I don't have anything to do with that. So as soon as our clerk, Madam Clerk, Ms. Alexander, and her team spin that, that's not my information in purview.
Can expedite and say does have their concerns that you hold the jury will definitely regard this matters and it will be expedited so that those systems made a motion to.
Well, I understand your concern. I think the rules of transfer and recusal are pretty clear. And I'm not going to comment on anything that. So, hopefully it will get in terms of some of the acting. Okay. Anybody? Mr. Steele, you rose a second ago. Do you want to say something, sir? Okay. Okay. Then we're in recess and see you in a little bit. Okay.
Hi, yeah, hold on, y'all. Hold on a second. I'm gonna show you the other one from my camera. Okay, from the other camera. This is where we're looking at Hilton throughout the whole time. Hold on a second. You guys heard what Mr. Harvey said in regarding to it being another judge from another county. He says the judge is going to be sent over to a judge in Fulton County, but that judge is going to have to remove himself and they're going to go to a judge that's out of the circuit. That's what Mr. Harvey said. Did you guys get that when he said that earlier? I know people putting false information out there, but it was said by the attorneys that in fact it's going to have to be from another judge. All the attorneys said that. Another judge that's not in the county. Okay, you heard it. Okay. So you guys know it didn't come from me, it came from an attorney saying that. Okay. Hold on a second. Now this is going to be from Hilton. And guys, this is not for quality of sound. This is for reaction to certain things the judge was saying. Okay, I know I have to say it 1,000 times because people keep coming in here and say, "Oh, this sound sounds terrible. It's not good quality of sound." Okay, and I do have the proffer too. I have the proffer and I have the motion that Love submitted today. Okay, I have both. Now this one is going to be Hilton while the judge is speaking. Okay, so here it goes. Y'all say Lord Hilton. I just wanted to show you the different angles. Okay, there we go. We don't have to hear the judge again, but you're just seeing a different angle of the everything. Okay. This is from Hilton's side, so you can see what she was doing. You didn't get a chance to see that from the live view, the live during the hearing. I'm just giving you guys extra, okay? You're welcome, Janelle. This hearing is basically about just what, roughly about 20, 30 minutes the most. I was told that Love is taking care of some other things when I asked.
Okay. Right for the top. All right, thank you, David.
Adam, he was taking care of it. I think he's doing something, having to do with a case or something like that. I don't know.
As you all are aware, as parte proceedings on June 10, 2024. In considering whether or not to have him discuss.
Well, we don't have to hear the judge continue talking. What we can do is move up to where Hilton is talking. You want to do that? Thank you, Nona.
On Friday, June 7th, 2024.
Bumpus had 5 lawyers, 2 women and 3 guys. Okay, let me move over. They said, yeah, to move up. Hold on.
Mr. Adams and Mr. Sharp. Tonight, I think we agree to seek to go forward.
Okay, this is, we're going to go all the way to the end. Now we're going to go to her. Hold on a second. Let me go get hers. Hold on a second. Let me go get her other one. All right, hold on. Because we don't want to hear the judge saying the same thing over and over again. Here it is. Let's do this where Hilton is getting ready to talk to the judge, okay?
7, and you'll see him. That has to go to another judge pursuant to our local rules. So it will be basically put on the wheel. Of course, I don't have anything to do with that. So as soon as our clerk, Madam Clerk, Ms. Alexander, and her team spin that, That's not my information can prove.
Can expedite and say this in very terms that we hold true to that. Expedite so that Wilson has made a motion to.
Well, I understand your concern. I think it means that transfer and fees are pretty clear. I'm not going to comment on anything that is pending at one time. So, hopefully it will get done very quickly in terms of some of the acting. Okay. Anybody? Mr. Sealy, you want to say something, sir? Okay. Then we're going to recess and we'll see you in a little bit.
All right, that's that on that. Okay, now we get ready to get into our documents, y'all. We are getting ready to get in our documents. Let me just go ahead and pull this up. All right, here we go. It's the first document right here. All right, this was filed on today at 11:20, and it's the certificate of discovery supplement. This is to certify that I have this date in accordance to OCGA 17-16-1 Esquire, serve counsel of record for the above listed defendant with a copy of the following marked items lockbox. We, the state, are also filing a certificate with the court. However, the media listed below Dropbox, due to its nature, have not been filed with the clerk office. Brady material, DDA Hilton to defense counsel, due to its nature, have not filed with the clerk's office. If you do not receive any of the above check item, please contact the prosecutor immediately. If the defendant elected to opt into the discovery process under OCGA 17-16-2 as required and subsequently refuses to receive discovery via Dropbox link, any and all discoverable items in the state's possession, to include physical evidence associated with this case, are available for examination and copies by appointment only with the undersigned Chief Deputy District Attorney. Please contact me at the above number to arrange compliance with OCGA 17-16-4B. I hereby certify that I have on June 6, 2024 at 8:10 p.m., June 10, 2024 at 6:54 a.m., and June 12, 2024 at 9:23 p.m., 2024, serve the within and foregoing Brady material upon the counsel of record for the defendants by mail to the court and said attorneys. Brian Steele Esquire, Keith Adams Esquire, Angela D. Williams Esquire, Nicole Westmoreland Esquire, then you rest, Karen Carlton and all that. I don't feel like reading the rest. So does that mean they had Brady material missing and they just submitted? Does that mean that, y'all? I wonder who was the DA webcam called at the time. I don't know. Okay, now the next one is Steele's motion today. Hold on. All right, here it is. All right. This is Steele's motion. Notice of attorney proffer after being prohibited from cross-examination and presenting a full critical defense at trial. Now comes Mr. Jeffrey William by and through undersigned counsel and hereby files this notice of attorney proffer after being prohibited from cross-examination and presenting a full critical defense at trial in the above referenced case. In support of this notice of attorney proffer, Mr. William undersigned counsel show as follows. Background and attorney's proffer. On Tuesday, May 14, 2024, during the direct examination of Agent Rossi, lawyer Hilton, representing the state of Georgia on behalf of Fulton County District Attorney's Office, played over confrontation clause and hearsay objection on October 22nd, 2015 at 9:33 p.m. recorded jail call of Mr. Jimmy Winfrey and a person known as Rashad. During this October 22nd, 2015 recorded telephone call, Rashad explained that he heard from another unknown person that a Porsche vehicle as well as $250,000 was waiting to be given to Mr. Winfrey once he finishes serving time in custody. The prosecution theorized that this vehicle and money were rewards for Mr. Winfrey's silence, not to speak with law enforcement about who, if any, was supposedly the persons responsible for the April 26, 2015 bus shooting and other gang-related crimes. See YouTube dated May 14, 2024 at 4850 and 5601. Y'all want to see that YouTube video? Do you guys want to see that YouTube video? Do y'all want to see that one? As part of this, y'all want to see it? Give me a yes or no. Okay, hold on. Okay, well, the time marker says 49 what? What is the timestamp? Timestamp is 48. Hold on a second, y'all. Hold on. Okay, guys. I am going to play this. It says from 4850 to 5601. 4850. 4850. 4850. Okay, I'm gonna take my thing off because it's not mine. Take this off because it's not mine. It's not mine. Okay, it's 4850. 4850. Okay. Okay, let's play it from here.
Councils.
No, I heard the same, I understand it the same way, so no.
All right, okay. It's admitted.
Thank you, Your Honor. Now, looking at the screen, what is the date of this call?
October 22nd, 2015.
And we can go ahead and publish.
This is a global Tel-Link prepaid call from
It's me.
an inmate at the Cobb County Adult Detention Facility. This call will be recorded and monitored. Your IGS account balance is $29.69. If you have questions or complaints about this call, please call customer service at 1-800-231-0193. To hear the cost of this call, press 8 now. To accept this call, press 5 now. This is a global Tel-Link prepaid call from
It's me.
your IGS account balance is $29.69. Complaints about this call, please call customer service at 1-800-231-0193. To hear the cost of this call, press 8 now. To accept this call,
Yo. Dion went out like radio. Hello. Yeah. What show that?
Hold on, I'm finna call him back.
What did you tell me that, Sean?
Man, he won't tell my shit. He said when you get out, you gonna have a Porsche.
Yeah, tell him to give it to you.
Nah, he told me you do that. You know you gonna do that, man.
Yeah, he ain't the man.
You gonna get you a Porsche, man.
You ain't got no choice. Hey, man, like what Bobby said, you better guard your crib.
We sit out for a couple months for a Porsche in quarter million.
Hey, come on. Hey, my brain changed now. Hey, for real. Hey, man.
Something like that. It's a fan, how you need to get out.
Hey, come on. Call.
Now, do you remember what time that call was on October 22nd?
It was 21:33, so 9:33 at night.
And was this call made on Mr. Winfrey's PIN?
No, it was not.
How were you able to find this call?
By doing basically kind of like a reverse search, basically giving the phone numbers that I had previously observed Mr. Winfrey calling to the custodian of records at Cobb County and having them query those phone numbers in their system. So then in doing so, I could see that basically these calls were listed from Winfrey, and then all of a sudden there's a couple calls to that same phone number in another inmate's name. And so I requested those and received those.
And the phone number that you queried, did you have a name associated with that phone number?
I likely did. I need to check the report if you don't mind to refresh my memory.
We're
but
looking at your report, help refresh your memory.
It would.
We're looking at 60171 Echo, help refresh your memory. It should be right in front of you.
Yes, my report, yes.
And directing you to page 183.
Okay, yes.
Who was the, is your memory refreshed?
Yes, yeah. Are you gonna want me to memorize that phone number to repeat it for the record?
No,
Okay.
just the name that was associated with the,
Rashad or Shad, something to that effect. I put Shad in my report.
and in listening to the previous jail calls that we listened to yesterday, was that name Shad familiar to you, given some of the other calls?
I'll sustain the objection. That's the form. You can rephrase.
Had you heard the name Shad prior to listening to this call?
Yes,
Where?
on other jail calls.
Were those jail calls we heard yesterday?
Those are some of them, yes.
In your review of the jail calls, did you hear more calls with this individual by the name of Shad?
Yes, that's correct, yes.
Now, why was this call significant to you?
I heard a money value and a valuable car being discussed in it.
What was the money value you heard?
A $250,000, 250,000.
And what was said about the $250,000, 250,000?
Basically, when he gets out, he'll have a Porsche purchased for him and a $250,000.
Now, was that Winfrey who said it, or was that Shad who said that to him?
Shad that said that to Winfrey.
Now, sitting here right now, do you know if Jimmy Winfrey was ever paid $250,000?
I don't know that.
Do you know if he ever received a Porsche?
I don't know that.
Sitting here now, do you know if he ever received any compensation?
I don't know that information.
Was there anything else of significance to you regarding this phone call?
I mean, the fact that he was using someone else's PIN, so it was something that was at least being attempted to be concealed through his own PIN number.
I'll overrule the objection.
Yeah, so that's pretty much it. That there's my interpretation was there's a reason why it was used on.
I'll sustain as the form.
What was your interpretation of him calling under a different PIN number?
Overrule, sir.
There's a reason why it was not on his PIN number.
As it relates to this case, do you know if Jimmy Winfrey ever took a plea in this case?
He did.
In relation to this phone call, how much time passed before he took a plea?
It was approximately a month later, or maybe a month and a day, but a month later.
Sir.
Okay, they reference up to here, but guys, I'm gonna have to postpone this because I have to return an important call. But I am gonna return back because I noticed still reference George Cheaty's account of us hearing about Copeland knowing the state and the judge knowing that Copeland was going to take the plea. I'm going to put the article in there in the chat for you guys to take a look at it, because hold on a second, y'all. Hold on a second. Hold on. He put it in there with us. I'm going to make a copy it and put it into your so you guys can read it. It is part of the okay, here it is, guys. Y'all can go take a look at it on your own. There it is right here. You can go take a look at it and read it, and I'll be back later on to bring you the rest of this, okay? Just click that link and still put that as part of the proffer. Okay, this is when George Chidi and I was told to that we couldn't videotape because Copeland was going to be arrested that day. So it gives you guys a chance. But I do have to get off because I have to make this important phone call. My apologies, but I just have to what time later? Let's do because this person is gonna go to bed, but I'm gonna let's do 9 o'clock. Is that too late? 9 o'clock? Is 9 o'clock too late? I'm gonna do 9 o'clock because I gotta take this call. All right. So we'll have part 2 to this for the okay. All right. Thank you guys. I'll see you guys You said Scholar said why bother? Why bother? I don't know. I don't know what she's talking about, but okay. If it's a bother for you, you probably don't need to be on there. See, I try to be nice. I try to, but y'all be coming at me like this. But here's the link for you guys. How about you just not come in here? I am a he. Okay. All right, guys. You guys, I see you later. That's a troll. Okay, let's block this troll because I'm tired of her. Okay. All right. I'll see you guys later. All right. No need to even threaten Doc. I got her, he, she, whatever. I'll see you guys later. And whoever you are, you stop spamming my stuff. Let me ban him. All these weirdos coming in here. Okay, I'll see you later. All right.